I don't know why he asked me if I have to, unless you want it, I say I do, he hasn't come over to read it. Because he asked me if I had it, I'm like, yeah.
You're okay? Okay. Good morning, my name is Judge Kathleen McCarthy. You are here for first appearance hearing, and there's 3 reasons or purposes for this hearing. Number 1 is probable cause. The first purpose is to determine if there's probable cause for your arrest, which means whether there are reasonable grounds to believe a crime may have been committed and you are the person who committed the crime. If I find there's no probable cause for your arrest, one of 2 things may occur. I may give the state up to 24 hours to produce additional facts to show probable cause, or I may direct you to be released. If you are released for lack of probable cause, it does not mean that the case is over. It only means that you will be released from custody. If the state wants to proceed against you on these charges, it has the right to do so. The second purpose is to determine whether you should have a lawyer appointed to represent you. You'll have a right to counsel. If you have an attorney and you want to reach him or her, you should advise me and I will direct the bailiff to attempt to reach him or her. If you cannot reach your attorney, this proceeding will have to be delayed. If you want to have the public defender appointed to represent you, please let us know. I will appoint the public defender to represent you if you qualify for services of the public defender. You must fill out completely an application for indigency, which will be provided to you. And the clerk of court will determine if you meet the statutory criteria for having a public defender appointed to represent you. You will be charged $50 for the processing of the application, which is due 7 days from the date of the application. Please understand the services of the public defender are not free. If you eventually enter a plea of guilty or no contest, or if you're eventually found guilty of the offense for which you are charged, then a judgment may be entered against you for the reasonable value of the public defender's service. The third purpose is to determine what type of pretrial release, if any, should be set in your case. Each of you have the right to remain silent under the Fifth Amendment to the United States Constitution. You are not required to say anything, and anything you say may be used against you. You also have a right to communicate with counsel, family, or friends, and if necessary, you will be provided reasonable means to do so. Rebecca Dawn Anderson.
Your Honor, they said they did not hear anything you just said.
Oh my gosh. Okay.
You have the volume on and everything?
I have the system on, speakers are on. Who do,
Judge, the volume is really low on the microphone for some reason. It was working perfectly yesterday and now.
okay,
The
Mr.
volume's low
Romero,
again.
thank you. We're gonna try to figure this out.
A little bit, it's a little better. It's a little better right then.
How about now?
Did you turn up?
Beautiful. Yes, sir. Yes, sir.
Okay, Mr. Romero, I'm gonna do my opening again, okay? If you could just give me a thumbs up to let me know you can hear me. Good morning, my name is Judge Kathleen McCarthy. I'm your judge this morning. You are in first appearance court. Today is the day I will inform you of your charges, determine whether there is probable cause for those charges, and then determine whether you can be released from custody. Please understand that today is not your trial. You will not be found guilty or not guilty today. Since today is not your trial, you do not need to comment on your arrest or the facts surrounding your arrest. You have the right to remain silent. You should use that right at all times. However, if you give up the right to remain silent, whatever you say about your arrest or the facts surrounding your arrest will be used against you. This hearing is being recorded. If you have a private attorney, please let us know when you're being called forward. All right, Mr. Romero, how was that audio, okay?
Excellent.
Okay, thank you. Rebecca Dawn Anderson?
Paul Ryan, I believe, Judge.
Thank you. Rebecca Dawn Anderson?
Is there a deputy there? The lights are on. There's some defendants, I just don't want to take the deputy in there.
Mr. Romero?
Yes, Judge.
We can't find her at Paul Ryan.
Oh, according to the docket, it seems to indicate that's where her location is. Maybe I can have one of the deputies here try and find her location, Judge.
Okay.
Or confinement status is right there. They can actually see.
Okay,
She is at Paul Ryan.
she is?
Yes, sir, she's on the way, Your Honor.
Okay, thank you, Deputy.
Yes, ma'am, sir.
Your Honor, Eric Linder on behalf of the state, it's probably gonna be a few minutes before they get her down there. I have no objection if you wanna move on to the next case and put it
Okay.
on recall.
Sure. Lonnie Landry? Lonnie Landry?
He's approaching, Judge. He's here at Maine.
Okay, thank you. Good morning, Mr. Landry.
Good morning.
It appears that we have an out-of-state hold, out of California, sir. Okay? Mr. Romero, any questions?
No, I was just explaining to him he's this out of state, can't really do anything. You'll be brought to extradition court. Usually, I believe it's Tuesdays or Thursdays.
Okay, thank you, Mr. Romero. Good luck, Mr. Landry.
Okay, good luck, sir. All right.
Dennis Dean Williams?
Mr. Williams, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Williams.
Good morning, Your Honor.
You've been detained. You have an out-of-state hold for the New Mexico.
That's what I found
Okay,
out,
sir? All right, good luck, sir.
Your Honor,
Yes.
I received a call from Paul Ryan. They're advising that
Rebecca is ready?
no, the unit that she's in is currently being swept by the K-9 unit. So
Okay.
if you could call her at the end of the docket.
Yes, thank you. Shawana Johnson?
Main jail.
Ms. Jackson, Ms. Johnson, here present, Judge, I mean.
Good morning, ma'am. It looks like we have 2 capious misdemeanors, and we have a status in your case on October 9th, 2017 at 11 a.m. What say you, State?
Your Honor,
Ms. Johnson advised me she's gonna be posting her bond.
Okay, thank
say
you.
nothing.
Did you hear that, sir?
Yes, I did.
Do you have any questions or?
No,
Okay. Mr. Romero will find probable cause and she'll be posting the bond?
Yes, Judge.
Okay, thank you.
Thank you.
Laura Wade?
North Broad, Your Honor.
Good morning, Miss Wade. You're here today, you have a violation of probation on a misdemeanor. And it looks like you have a violation of probation hearing on October 12th at 10 a.m. What say you, State?
Your Honor, just asking that the bond that Judge Brown set be kept in place.
Okay,
Judge, most times when there's a warrant set, bond remains the same.
okay, ma'am, your bond is set at 5,000, okay? Good luck. And don't forget you have a hearing on October 12th, 2017 at 10 a.m.
Your Honor,
Yes,
Rebecca Anderson is ready at Paul Ryan.
okay, great, thank you.
This was a quick sweep.
Good morning, Miss Anderson, how are you?
Good morning, how are you?
Good, okay, so it looks like we have 3 charges. We have 3 out-of-state holds for Virginia, ma'am. Okay,
Okay.
so it looks like you'll be going to Virginia. Good luck with everything.
Are they coming to pick me up?
She'll have an extradition hearing in the coming days before Judge Bailey.
Okay, thank you, State.
You're welcome.
All right, so you'll be in front of Judge Bailey and the arrangements will be made then, ma'am, okay?
Okay, can I ask you a question?
Yes.
Is that, so they said that they're for sure coming to get me? Or
That,
is it still questionable?
Let me defer to the state on this.
all of these matters will be addressed at the extradition hearing before Judge Bailey.
Okay, Judge Bailey will be able to answer your questions, ma'am. Okay?
And when's the hearing?
It's gonna be in the next few days. I'm not sure
Okay.
which date.
Either end of this week or early next week.
Okay, did you hear that,
Okay.
ma'am?
Yes, ma'am.
All right, good
Thank
luck.
you. Thanks.
Janiyah Marlene Bell?
Ms. Bell is here, present at Maine, Judge.
Okay, Mr. Romero. Good morning, ma'am.
Good morning, ma'am.
Okay, so it looks like we have several charges. Number 1 is false ID given to law enforcement officer. 2, operating motor vehicle with a license expired. And then we have juvenile orders on 3, 4, 5, 6, and 7. What say you, State?
Your Honor, in light of the fact that she's got no bond juvenile holds, multiple failures to appear as a juvenile, I'm just asking that the $100 bond on the false ID be kept in place.
Okay. Mr. Romero?
Judge, in reference to Ms. Bell, I do understand there's nothing the court could do in reference to counts 3 through 7. Considering she has a no bond hold, she has to go in front of her assigned judge to have those holds taken care of. I'm going to be contacting my juvenile supervisor to see how soon she could probably get a court date to address those matters. And the alternative, what I'd be asking you is to consider ROR on count 1, so that if we manage to somehow address her juvenile cases, there's no sort of impediment as far as allowing her to post her bond or anything like that. So I'd ask you to consider an ROR on her behalf, Judge, on count 1 only.
Okay, thank you. The court does find probable cause with regard to count 1. The court will ROR her, okay?
Thank you, Judge.
Good luck, ma'am. Sheena J. Torres?
She's over at the North Broward jail.
What was
North
that?
Broward.
Thank you. Good morning, Ms. Torres.
Good morning.
You've been charged with burglary of an unoccupied structure, unarmed. Charge 2 is petty theft, first degree. And number 3 is burglary of an unoccupied structure, unarmed. State?
Your Honor, Ms. Torres was arrested exactly 1 month ago, and she's out on bond for possession of cocaine and child neglect. State, in light of that, the state would be asking for bonds in the amount on counts 1 and 3, $5,000.
Each?
Yes.
Judge, in response, I can tell you that she's currently not working. She lost her job a little bit less than a year ago. She used to work at Flanagan's. She can live in North Miami with her ex-husband. She did provide me a number. She has no money in the bank and owns no property. There's not much she can afford in bond right now. She'd be relying on her ex-husband to bond her out. She was in an accident a few years ago, and she has some medical conditions too. I would respectfully ask, maybe the court can consider least restrictive options in determining bond and release conditions. I do have a number for her ex-husband, maybe put her on a monitor, because I can't in good conscience say that she can afford a bond at this juncture.
Defense, let me ask you something. Is she gonna live in Dade County?
Correct.
And how would that work if, for example, if she was on pretrial and she lives in a different county?
That's fine. They can live in the Tri-County area and still be supervised by pretrial.
And Your Honor, the state would object to pretrial. Pretrial is really really defendants with no record or a history that doesn't really involve anything serious. Here, she's accused of 2 separate burglaries, while she's not supposed to be committing any new law offenses to begin with because she was arrested on 2 felony charges a month ago.
Well, Judge, in considering bond and release conditions, the court can, while processing whether or not to set a monetary bond, the court can set restrictive conditions on her. That bond she can't afford. Just hearing that she has a child neglect case, we know that she's a child net is involved and they have her on a plan. If we put her on a monitor, put her on a schedule, I mean, that would be more beneficial to her too. So that's, I mean, I would recommend a bond, but there's not a bond she can afford right now.
Okay. All right. Pretrial. If you could just apprise the court as far as restrictions, we could get her a GPS monitor, correct?
Yes, you can get her a GPS monitor. The most restrictive pretrial would be level 1. That's total lockdown. She wouldn't be allowed to go anywhere except visits with her attorney and medical emergencies.
Okay, and that's level
1.
All right. And tell me about level 2?
Level 2 is where she would have to set a weekly schedule with the pretrial officer. And then
Okay.
they also have open schedule where.
All right, so the court's gonna find probable cause. You'll be out on pretrial level 2. I want you to phone in at least twice a week.
I do have a number for pretrial she gave me. I mean, for her ex-husband. You can live there, right?
Yes, sir.
Your Honor, I don't know that I mean, they normally don't have people calling when they're on a GPS because they know where they are, or should know where they are as long as she doesn't tamper with their GPS monitor.
Okay, in light of the ChildNet case, this is what the court's ordering as well. Yes. April Blakely?
Ms. Blakely is here present at Maine.
Okay.
She declined the service of public defender. She has private counsel, Judge.
Okay. Hi, ma'am, what's the name of your attorney?
My sister got him for me. I don't know his name.
Okay. Mr. Romero,
Yes, Judge.
could we provisionally appoint you for today's purposes?
Well, she would still have to fill out the form and everything like that. She'll be charged for it. And unfortunately, I believe this is a violation of probation, no bond hold. She's going to be seeing her judge on October 6th. So I believe she's going to go ahead and have her attorney appear on her behalf on October 6th, Judge.
Okay, is that correct, ma'am?
Yes, ma'am.
Okay, so your hearing is gonna be set on October sixth, 2017 at 9 a.m., okay? All right, good luck.
All right. All right.
Good luck, ma'am.
Cacciano Floristo?
She bonded, Judge?
Okay, thank you. Vanessa Moss?
She's here present, Judge, at Maine. She declined the service of the public defender.
Okay, ma'am. Good morning. You've been charged with passing a forged, altered bill or promissory note, as well as grand theft. And you're declining the services of the public defender, ma'am?
I have a private lawyer.
Do you know your lawyer's name?
No, ma'am.
Okay, so what would you like the court to do?
Mr. Mace?
Do you want to try to call your lawyer?
I guess, yeah.
Okay, ma'am. See if somebody can assist you with contacting your attorney and we'll call your case back, okay?
Okay.
Tamara Brown?
Judge, just to help the court as a friend of the court,
Yes.
I believe Ms. Moss did advise me she just plans on posting her bond and I believe contacting her family to see who, to speak to her attorney when she bonds out.
Okay, so ma'am, is that correct?
Yes.
Okay, then for today's purposes, the court's gonna find probable cause with regard to count 1, bond will be set at 1,000. With regard to count 2, bond will be set at 1,000.
Okay, thank you.
Thank you, good luck, ma'am.
Good luck, ma'am.
I've had it since you asked me.
Okay, Tamara Brown?
Ms. Brown is here present, Judge.
Good morning,
Judge,
Ms. Brown.
I've been informed she declined the services of public defender.
Could I ask about
Yeah, you can ask her whatever you want.
Okay, ma'am, you're being charged with aggravated battery causing bodily harm or disability. Are you sure you don't want the services of the public defender today?
I have a law. Well, I don't know for sure yet until I get in touch with my people. But I was wondering if I could get a R bond until my court date.
Did you want to go forward right now without an attorney, ma'am?
If it's okay if I get on RR right now, I don't
Still
know.
negotiation.
I don't know. Yeah,
Okay,
I don't know.
all right. Can you get Mr. Romero?
Yeah, I don't know.
Hi, Mr. Romero. Can you talk with Ms. Brown for a moment? Do you mind?
No problem, Judge.
Thank you.
Thank you, Adam.
outright.
Judge, she changed her mind. She wants me to assist her, and I do have information to
bad.
share with Your Honor when the state, gives you their info.
Okay, thank you. State, what say you?
Your Honor, I'm asking the court to keep Judge Yusan's bond in place. This involves, it's a second-degree felony, involves a high level of violence, causing the victim to require 10 stitches, 11 staples. I believe she has no ties to the community. She was extradited to Broward from South Carolina. She also has a history of violence out of South Carolina. In 2015, she was convicted of assault and battery in the 3rd degree. She also had a possession of marijuana in 2013. Also asking for an additional condition of no victim contact.
Thank you, State. Mr. Romero?
Judge, that is correct. She was extradited from South Carolina. She was in custody of, from what she informed me about, 10 business days prior to arriving here in Broward County. She lives in South Carolina, specifically the city of Dillon. She resides at the same address for the past 3 years. She lives with her mother. Her monthly portion of the rent is approximately $300 per month. She works for QVC in their packing department. She makes approximately $11 an hour. Making $11 an hour is going to be hard for her to be able to come up with $10,000 as far as a bond. She's going to be relying on her mother to help her and assist her posting her bond, and her mother's a substitute teacher. She does have family also that resides here locally in Broward County, her aunt specifically. She's also going to be trying to contact her aunt to help assist with the bond. But from what she told me, she doesn't think that they can come anywhere close to $10,000. I do understand as far as this is a second-degree felony, Judge, but I'd be asking you at the very least, Judge, to potentially reduce this from $10,000 to $5,000. That might even be too much, but at least that's something they could strive for as far as posting a bond.
Okay, Mr. Romero, thank you. The court's going to find probable cause. The court will keep that bond at $10,000. And ma'am, you're to have no contact with the victim, either direct or indirect, and I want you to stay at minimum 500 feet away from the victim. Do you understand, ma'am?
Yes.
All right, good luck. Cicely Andrea Mack,
It's gonna be a medical reset, Judge.
this will be a medical reset?
Yes.
Thank you. Charnel Nicole Johnson?
Paul Ryan, Judge.
Your Honor, I think, well, she might be downtown. She's scheduled for arraignment before Judge Lynch this.
I'm in Paul Ryan.
Can I just have one moment, Your Honor?
Ms. Johnson, could you just hold on one moment, please? We'll be right with you. Yes, Dave?
Oh, I think she had her arraignment yesterday, Your Honor.
Okay.
What I'm gonna ask, since this case has already been handled by Judge Lynch and it's really in his jurisdiction, L'Oreal, could you tell me what the bond was set at?
There was no bond set.
No, what was it originally set at?
25,000.
25,000? Your Honor, Judge DeLuca originally set this bond at her first appearance at 25,000. Really, I believe any bond modifications at this point, since she's been arraigned by Judge Lynch, has to be set by him. So I would ask that the bond be kept at the original 25,000. It was, one moment, Your Honor. Drug possession, and I don't think there's a bond attached to count two, or drug paraphernalia. Yes, the only difference, Your Honor, between the original charge, it was a burglary conveyance across county lines. We filed it as a burglary conveyance. Frankly, on the face of it, and I don't know that Judge DeLuca would have taken the across county lines into consideration because it shows her residence as being Pompano Beach, and there was never any allegations in the original affidavit that she crossed county lines, Your Honor.
So what are you suggesting, sir?
That the bond be kept out, the same bond that Judge DeLuca originally set when he reviewed when she had her first appearance. It's the same circumstances. The only changed circumstance is the enhancement for across county lines, and that's why I mentioned there was nothing in the original affidavit to suggest that this was across county lines. I can.
Okay, hold on, ma'am. Just to let you know, in case I didn't tell you, your charge, burglary, unoccupied conveyance, unarmed. You also have a capious felony out. All right.
Judge, well, Fact of the matter, since her arrest, she's been in custody. She can't afford the $25,000 bond. If the court is inclined to consider modifying bond conditions, can I ask her a couple questions?
And Your Honor, again, the reason the only reason I'm asking the court to keep the bond of $25,000 is respectfully because she has been arraigned by Judge Lynch. I believe he would have to make a determination of any bond modifications at this point.
Sir, I'm inclined to agree with the state this time. All right, so respectfully. All right, ma'am, the court's gonna find probable cause. We're gonna leave
Ma'am,
bond.
can I ask a question?
Go ahead.
The charge was changed from across county lines, which was a second-degree felony. They switched it to a third-degree felony.
Okay, ma'am, well, here's the situation. You're gonna be in front of the assigned judge on October 10th at 9 a.m. So you could bring that up with him, sir. Good luck.
All right.
Narhan Trujillo?
Mr. Trujillo is present here at Maine, Judge. He's inquiring with the court if the court would consider resolving his case today for time served.
Good morning, Your Honor.
Hi, sir, how are you? So you have two charges, capious misdemeanor, and that's on case number 17006206 MM10A, and another capious misdemeanor on 17005209 MM10A.
I believe they're the same case numbers, Judge. They're 176209 MM10A.
Okay, thank you. State, anything?
One moment, Your Honor, I'm just looking at the original probable cause affidavit. Your Honor, the state's offer to be an adjudication time served.
Let the judge know if you want to accept it when she asks you, okay? Okay.
Okay, sir. Do you swear or affirm to tell the truth today?
Yes, ma'am.
Okay, is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional issue?
No, ma'am.
Do you understand the proceedings today?
Yes, ma'am.
Do you understand you are waiving your right to an attorney into trial?
Yes, ma'am.
And are you pleading no contest to the two charges with the capious misdemeanor, sir?
Yes, ma'am.
I accept your plea and find it freely and voluntary given. The court will take judicial notice of the time spent in jail. The court will withhold adjudication, and you have 12 months to pay court costs. Do you understand?
Thank you. Yes, ma'am. Thank you.
Yes. Yes. Okay, so the court's gonna take actual judicial notice to the time served, okay, sir?
Great. Thank you.
Alrighty, thank you.
Thank you.
Brian Devin McCree?
Mr. McCree is here, present judge at Maine. He's also inquiring if the court would consider resolving his case today for time served.
Okay, sir, you're being charged with trespassing, occupied structure, or conveyance? State, anything?
One moment, Your Honor. State's offer would be an adjudication time served. The state would request that the court not offer him a withhold. He has a lengthy criminal history. He just was released from state prison July 4th of this year. numerous drug dealing charges he's gone to prison in the past for.
Mr. Romero, what say you?
Judge, let me ask him if he wishes to accept the state's offer.
Eric, do you have the burnt bat?
Okay,
bat
He
sir.
still wishes to go forward, Judge.
Please raise your right hand. Do you swear or affirm to tell the truth today?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand the proceedings today?
Yes, ma'am.
Do you understand you're waiving your right to an attorney and to a trial?
Yes, ma'am.
Are you pleading no contest to the crime of trespassing of occupied structure or conveyance?
Yes, ma'am.
I accept your plea and find it's freely and voluntarily given you. I sentence you to time served. The court adjudicates you, and you'll have 12 months to pay court costs. Do you understand?
Yes, ma'am.
All right, good luck, sir. John Preston Gilmore.
Mr. Gilmore's here, present judge at Maine. He is approaching on counts 1 and 2. Both counts are municipal ordinances. Public Defender's Office unfortunately cannot represent him on municipal ordinance cases.
Okay, Mr. Romero. Good morning, sir. So we have 2 capious misdemeanors for case number 17001775 MO40A, as well as 170014440 MC4DA. Sir, did you want to resolve your case today?
Yes, ma'am.
Okay, hold on. State?
Your Honor, the state does not prosecute municipal ordinance offenses.
Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, I want to resolve it today.
Okay, very good. Are you under the influence of any type of alcohol or drugs?
Not today.
Very good. Have you ever been treated for mental or emotional illness?
Yes, ma'am.
All right. Does your mental or emotional illness prohibit you from understanding what's going on today?
I understand this.
Okay, thank you. I don't need to ask these questions. Thank you. Do you understand you're waiving your right to an attorney and to a trial?
Yes.
Are you pleading no contest to the 2 capious misdemeanors?
Yes.
I accept your plea and find it is freely and voluntarily given. The court's going to withhold adjudication. We'll take judicial notice of the time served, and you're going to have 12 months to pay the court costs. Do you understand?
Yes, ma'am.
All right, good luck.
Can I say something,
Yes.
ma'am? I'm originally from Cleveland, Ohio. So, I have no money. I'm on disability. Been on disability since I was 4 years old.
Okay. So that's why we gave you 12 months to pay the court costs, okay?
Okay.
All right, good luck,
Thank you.
sir. Jim Mihu?
He's approaching, Judge. He's here at Maine.
Okay, good morning, Mr. Mihu. We have 2 charges, trespassing property, as well as a capious misdemeanor, in case number 1700-1641 MM20A. What say you, state?
Your Honor, the state would offer Mr. Mihu adjudication time served on both counts. Mr. Mihu has a lengthy history. He's out on ROR on a felony drug offenses right now as well.
Judge, if I could have 1 second to speak with Mr. Mayhew?
Yes.
Thank you. Judge, Mr. Mayhew wishes to accept the state's offer, Judge.
Okay, does he understand what he's accepting? The
Adjudicate
adjudication?
time served on both 1 and 2. He didn't fill out any paperwork with the Public Defender's Office, so Basically, Judge, at this time, he's gonna be proceeding, and accepting on his own this offer, Judge.
Okay, Mr. Romero, thank you. Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Do you suffer from any mental or emotional illness which would impair your ability to understand what's going on today?
No, ma'am.
Do you understand the proceedings today?
A little bit.
Okay. Do you understand that you're waiving your right to an attorney into trial?
Yes, ma'am.
All right. And you're pleading no contest to a trespass of a property non-structured or conveyance and a capious misdemeanor. Is that correct, sir?
Yes, ma'am.
Okay, I accept your plea. I find it is freely and voluntarily given you. The court will adjudicate and sentence you to time served, and you will have 12 months to pay the court costs. Do you understand?
Yes, ma'am. I'll be released today.
As long as there's nothing else holding him, yeah.
Yes.
All right, thank you, ma'am.
Okay, good luck, sir. Garen Chenard Heath.
Judge, I've been advised, Mr. Heath bonded.
Thank you, Mr. Romero. Villefrance Bonon.
Mr. Bonhomme is here present, Judge. He did advise me, he's looking forward to his day in court, and he's gonna be posting his own bond.
Okay, all right, good morning, sir. The court's gonna find probable cause with regard to the charge of loitering or prowling, and bond is set at $25. Good luck.
Good luck, sir.
Kenneth Milburn.
Thank you, Judge. Mr. Melbourne's here present.
Okay, thank you. Good morning, Mr. Milburn. There's two charges: possession of cannabis, 20 grams or less, and a municipality ordinance.
I'm
State?
here, I'm there. Your Honor, if, I don't know if Mr. Milburn was interested in resolving. If he's interested, the state's offer would be a withholding court cost. One moment, I'm just checking to see. I see no criminal history. If he's not interested in resolving, I have no objection to an ROR.
Okay, thank you. Mr. Romero, what say you?
That's what I was gonna ask, Your Honor, if you would consider an ROR. He has a clean record. There's ways he could enter a drug court, and potentially get this off his record and maintain it as a clean record. So, Judge, I'd be in agreement with the state as far as an ROR.
Okay, so the court will find probable cause, and sir, we're gonna ROR you today. Good luck.
Thank you, Your Honor.
Alrighty.
Okay. Look out for a notice in the mail. You'll get one in probably about 3 weeks, 4 weeks, telling you when to come back to court, okay?
What's the next process?
Antonio Levon Hagaman? Conti?
Good morning.
Good morning, sir. How are you today?
I'm doing fine. How you doing?
Okay, we're here, the charge is a capious felony, and it looks like we have a status in your division on October 10th, 2017. State?
Your Honor, this is an ad charge. He had his, on count one, his bond was actually surrendered. He's got a $1,000 bond on uttering a forged instrument. I'm just asking that the standard bond on count two be kept in place.
Judge, I did have an opportunity to speak with Mr.
Okay.
Hageman. I can tell you, he is a full-time student at Whispering Pines. There are some mental health issues. In regards to the bond surrender, it's not that he missed court. His mom, he had an argument with his mom, and his mom surrendered his bond. I understand the ad charge is count two because the value of the check was over $300. But unless he has anything violent in his past or a history of missing court, which I haven't heard at this juncture, I would ask the court to ROR him. He's aware of his court date. The court is informed. The state has mentioned that he has a court date coming up. He has no way of affording a $2,000 bond. He is 18 years of age. He does go to school. I would
Where is
ask courts.
Whispering Pines located? Is it in Broward County?
I believe so.
Your Honor, and I apologize, I didn't realize at first. Like the other defendant, Mr. Hageman was also arraigned by Judge Lynch yesterday, so I would just ask that this bond be kept in place based on that. It really would have to be determined by Judge Lynch at this point.
Okay, the court's gonna find probable cause, respectfully, Mr. Faza, the court is gonna keep the bond at 1,000. Good luck, sir. Don't forget, you have a hearing on October 10th, 2017 at 9 a.m.
Thank you.
Okay. Valentino Andrew McFarland,
He's also at Conti.
Conti? Hello, sir, how are you?
Hello, how
Is he
are
on the
you?
list?
Okay, you're being charged with
McFarland.
robbery,
Can't be on those.
no firearm or weapon, and aggravated battery. State?
Your Honor, Mr. McFarland was actually arrested on September 30th on a charge of strong arm robbery. It's actually referred to in this report. Essentially the same MO for that strong robbery. The victim was mugged by up to 5 individuals, attacked and robbed. Your Honor, my concern now is with the second allegation that this is a pattern of a high level of violence targeting individuals, Your Honor, in the Wilton Manors area. I'm gonna be asking, his bond, Your Honor, on the first strong arm robbery said 5,000. Now that we're hearing a second one with an even heightened level of violence, the aggravated battery, I'm gonna be asking for bonds in the amount of 7,500 per count, with an order of no victim contact.
So with regard to charge 3 and 4, you're asking for 7,500 each?
Yes, Your Honor.
State?
Yes, Judge. Well, in regards to his ties to the community, he's a resident of Broward County all his life. He is gainfully employed. He lives in Lauderdale Lakes. He lives with his mother, and he has disabled siblings who he helps take care of. His mom's currently not working right now. I can tell you that he is gainfully employed. He does work in West Palm Beach. He works for Blackwater as a security guard, but he doesn't have any. He doesn't own any firearms, and as part of his duties, he doesn't carry any firearms. He makes $10 an hour working at Blackwater. He owns no property. His family's in a bit in a bind right now because his mom relies on him, and he's the only one working in his family. He only makes $10 an hour. Most they could scrounge up is maybe $1,000 of cash, and that's from help of family and friends.
Your Honor, and I apologize, I forgot to mention, Mr. McFarland's also being held no bond right now. At the time of his arrest, he was out on release for battery, and I believe Judge McHugh, it would appear Judge McHugh over the weekend revoked his bond on that matter.
Okay. So the court's gonna find probable cause with regard to count 3 and 4. The court's gonna set bond on count 3 at 7,500, on count 4 for 7,500. Good luck, sir.
Your Honor, just ask for a release condition of no victim
Oh,
contact.
correct. Sir, please come back. You're to have no contact with the victim, either direct or indirect. Do you understand?
Can I ask a question?
First, tell me, do you understand?
Oh, yes.
Okay,
Yes, ma'am.
additionally, sir, I don't want you to come within 500 feet of the victim. Do you understand?
Yes. Can I ask a question?
Yes.
I never,
Don't talk about the facts of the case.
Okay.
It's not time to do it.
Okay. Someone from your office will be assisting him, sir?
Yes, Judge, we'll send somebody out
Okay,
there.
so you have a private attorney that will be assisting you. Thank you, sir.
okay.
Anthony Sidicchioni?
Is he your present judge at Maine?
Good morning, sir. How are you?
Good morning, I'm well, how are you?
Okay, looks like we have a violation of probation felony, sir, and you have a hearing set in your division FI for that violation of probation on October 9th at 8:30 a.m.
I
Okay?
have,
I'm gonna argue there's no PC for attempted murder. The guy comes home at 5:30 in the morning. It could have been an intruder, or it could have been an accidental.
Well, that's a potential affirmative defense.
It's in there.
Then why?
All right, thank you. Good luck, sir.
My question is, why when he asked what happened, he said, oh, a flare went off accidentally.
supposedly,
That's
Lee
what's in the
Harris
report, that's what we have
Bernstein.
to go by.
He's here present, Judge Maine.
Good morning, sir.
What the court has to rely
Good
on.
morning, ma'am.
Okay, you are being detained for violation of probation, and you have a hearing in your division. It's Division FJ for your violation of probation on October 9th at 8:45 a.m. Okay, sir?
Yes, ma'am.
All right, good luck.
Yeah, I think so.
Clifton O'Neill Robinson.
Mr. Robinson's approaching, Judge. He's here at Maine.
Good morning, Mr. Robinson. You're being charged with the violation of probation, and you have a hearing in your division, FE, on that violation of probation on October 10th at 8:45 a.m. Okay?
Yes, but, I just got one question for you.
Yes.
I just landed a good job. There's no way I can get it by the 6th, so I'm gonna lose my job.
I'm sorry, sir, I can't assist you with that. But you do have a hearing set on that date.
Okay.
All right, good luck. Hi.
Morning, Judge, how are you?
Good. Which
Judge,
case
I have
you
on page 13, George Salimos, Mike Gottlieb on his behalf.
Okay, sir, just give me a moment, because I don't have the full docket, so I have to
Okay.
go through these individually.
No problem.
All right. Okay, I have it. George Salimos?
Judge, he has family and friends present in court. They're not gonna speak, but they just want him to know that they are present.
All right. Is he at the main jail, Mr. Romero?
He's at North Broward, I believe.
Okay.
That's him.
Good morning, Mr. Salimos. You're being charged with murder premeditated. Charge 2 is possession of a weapon or ammo by convicted felon. And number 3 is violation of probation felony.
Judge, not to correct the court, but I believe it's actually attempted murder as to the count 1.
Okay, hold on one moment.
I don't know why it shows as murder premeditated, but it is
The
attempted.
reason it says on the booking murder premeditated is because there is no attempted murder statute. So when they do the data entry, they put the statute for murder, and then they put, as you can see under the comment section, attempted.
Okay, I see that on the other form. Thank you.
Yes.
Thank you, sir.
Sure. And in reading the PC, Judge, I don't see probable cause for attempted murder in the first degree. The facts are that the roommate comes home at 5:30 in the morning and is shot in the face. It's a grazing blow. There's no facts that in the probable cause affidavit that suggest that there was any ill will between the two of them or any intent to kill him or harm him. It could have, and he didn't give any statement, so it could have been that he believed he was an intruder or that the gun went off accidentally. I don't see that there's probable cause to hold him for attempted murder in the first degree. With that being said, he is on probation and does have a no bond hold, but I wanted the court to know the facts.
Okay, thank you. State,
Your
what
Honor,
say
this,
you?
on count 1, which is a punishable by life offense, Your Honor, the state would be seeking a no bond hold. As far as the allegations, Your Honor, I believe the evidence is clear that Mr. Solomos did point a firearm at the alleged victim and fired. Your Honor, as far as Mr. Gottlieb's argument, I would note that when confronted by the victim what happened, there was no explanation that, oh, well, I thought you might have been an intruder. Oh, the gun accidentally went off. Mr. Solomos actually stated a flare accidentally went off my hand, denying that there was even a gun, Your Honor. I think there is evidence there based on Mr. Solomos' statement, that there was intent to fire a firearm and that there wasn't a justified cause for firing the firearm.
Okay. Anything else?
No, ma'am.
Okay, state, we'll give you 24 hours.
Your Honor, why is the court's not finding probable cause?
On number 1, no.
Why is that, Your Honor?
The court's not finding it.
I understand, Your Honor, but I need to know what the reason is in order to fix it.
The court's adopting the defense's argument.
Your Honor, what I would just note, the defense's argument, there's nothing in the report to support the defense's argument, Your Honor.
Likewise, there's nothing in the report to support that there's any intent to commit attempted murder in the first degree. In fact, the statement that the state elicited suggests that it's an accidental shooting. The fact that he says it's or believes it to be a flare gun is really irrelevant.
Okay, so with regard to charge number 2, the court will find probable cause. And number 3, there is the violation of probation felony. So, sir, you have a hearing on October 10th, 2017 at 8:30 a.m. And we'll give the state 24 hours.
Thank you, Your Honor.
Are you addressing the bond account 2 in 25 hours as well? Or?
What is your recommendation, state?
Your Honor, considering he's on probation for trafficking and drugs and he's in possession of a firearm, Your Honor, I'd be asking for a $15,000 bond on count 2 and allegedly used the firearm to shoot at someone.
I'm in agreement as to that amount, Judge.
Okay, 15,000.
Thank you.
Richard James Rudolph?
Mr. Rudolph, this is your present, Judge Maine.
Good morning, Mr. Rudolph. You're here on a parole violation? Yes.
Sorry, not that one, next one.
Okay. State, what say you with regard to Richard James Rudolph?
Your Honor, it's a parole violation. I really have nothing to add.
Mr. Romero?
Judge, parole violation is no bond hold.
Okay. All right, sir, good luck. The court does find probable cause. Felton Jerome Jefferson?
Mr. Jefferson is here present, Judge. He advised me he has private counsel, Mr. Jonathan Marnes.
Okay. Good morning, sir.
Good morning, ma'am.
Do you know where your attorney is?
Yeah, Jonathan Marnes. Do I know where he is?
Yes.
No, I don't.
Okay, I don't believe he's present at this courtroom. So we can reset this. Okay, sir?
Yes, ma'am.
Okay. Do you have somebody that can assist you with contacting him?
I was just arrested yesterday morning, ma'am, so, and I haven't used the phone because I wasn't booked in. I was sent to the infirmary because of a dog bite.
Okay.
I haven't used the phone since I've been incarcerated.
What's your attorney's last name again?
Marnes, M-A-R-N-E-S. Phone number 954-592-9090.
Okay, sir. See if someone at the facility can assist you with contacting him, okay?
Yes, ma'am.
I'll try and contact him after court, Judge.
Okay, thank you, Mr. Romero.
Probably so.
Okay, because I put like a little note. It's not that great. Yep. Okay, thank you. Alfonso Elliot Torres Reyes? Good morning, sir.
Good morning.
You're being charged with grand theft? The court does find probable cause. State?
Your Honor, state's asking that the $1,000 bond be kept in place.
Are there any priors, State?
No priors on him, Your Honor.
Okay, thank you. Okay, Mr. Romero, what say you?
Judge, I ask the state to confirm this is, from what he advised me, his first contact with the criminal justice system. He's been living in South Florida his whole entire life. He's 19 years old. He was working. He was making about $9.50. He did graduate from Boyd Anderson High School class of 2017. His eventual goal is to save up money and enter Broward College in this upcoming winter semester at Broward College. He lives in Davie with his mother in a trailer. They've been residing in the same location for about 7 months. His mom is employed at a gas station, so from what he advised me, financial resources are very limited. Judge, I'd ask you at this time, even though this is a felony, it's a nonviolent offense, you have a person who has basically strong ties to the community, never been arrested in his life, I'd ask you if you would consider an ROR on his behalf.
Okay, the court's going to find probable cause and will ROR Mr. Torres.
Thank you, Judge.
Your Honor, for Jefferson Felton, was he a PM reset or a reset for tomorrow?
For tomorrow.
Okay, thank you.
Thank you. Jean Ambeau.
Most Brown, Your Honor.
Good morning, Mr. Ambeau. How are you?
Doing good.
Okay. All right, you're here on various charges. We have a violation of probation. We have a capious felony, a third capious felony, fourth capious felony, and 5, an out-of-county hold. Let's see. For Palm Beach. State?
Your Honor, they're all warrants signed by his judges.
Okay. Sir?
Judge, I did have an opportunity to speak with him. There's no court date set, but he's aware of what's going on. I'm not in a position to recommend a bond.
Okay.
Maybe ROR count 1. Oh, I'm sorry, that's a VOP. I'll strike that.
Okay. All right, sir, the court's gonna find probable cause, and we will keep the bond for the violation of probation at 500. And obviously, you have those other capiouses in the out-of-county hold from Palm Beach. Good luck, sir.
When's my court date, Judge? Do I have a court date at least?
I was just looking at that, and it appears that it will be set. So that's the note I have that.
They will check the next available date on the judge's
coming in.
calendar and set a date.
Did you hear that, sir?
All right.
Okay, they're looking for an available date, and they're gonna set that as soon as possible. Scott Sobel?
He's here present, Judge. I mean, he is approaching.
Good morning, Mr. Sobel. You're here on a violation of probation. You have a hearing in your division for the violation of probation on 10/9 at 8:30 a.m. Okay? Good luck, sir. Jarvis Randall?
He's here present, Judge. I mean.
Good morning, Mr. Randall. You're here on 2 charges. Both are violation of probation. And you have a hearing set in Division FF on October 10th, 2017 at 8:30 a.m. Okay, sir? All right, good luck.
Good luck, sir. Frank Morera.
Good morning, Mr. Marrero. You are being held on 3 charges. Violation of community control felony. Charge number 2 is a violation of community control of a felony. And number 3 is violation of probation of a felony.
Excuse me,
Yes.
count 3 was correct, they should all be community control.
Okay, so let me rephrase that. Number 3 should be community control. Is that correct?
Yeah.
Okay, thank you. So, sir, you have a hearing set in Division FC for your violation of probation on October 10th at 8:30 a.m. Okay? Good luck, sir. Travis Gibbs?
I've been advised Mr. Gibbs bonded, Judge.
Thank you, Mr. Romero. Henry Mace?
He's here at Main, Judge.
Good morning,
ma'am.
sir. You're being charged with burglary with assault or battery. State?
Your Honor, again, this is a punishable by life offense. Under Isaza v. State, the state would be asking for a no bond hold and a finding of first appearance purposes only, a proof evident or presumption great. Relying upon the arrest warrant affidavit, Your Honor, the allegations would support the elements of burglary with assault or battery. And Your Honor, the weight of the evidence against Mr. Mace is strong. 2 witnesses, the alleged victims, identified by his driver's license, which he left at the scene of the crime, Your Honor. Also, victims were able to get a tag that had previously been assigned to Mr. Mace. Your Honor, also noting the state is seeking a no bond hold because it believes that Mr. Mace poses a danger to the community. His criminal record includes 2000 and, one moment, Your Honor. 2001 burglary of a dwelling, two burglaries, dwelling, grand theft, sentenced to 154 months Florida State Prison. 01 burglary of a dwelling and grand theft, just under 13 years state prison. In 2000, he was convicted of a burglary dwelling where he violated probation. Again, just sentenced to under 13 years state prison. He was released from state prison in October of 2012.
Mr. Romero?
Actually, my colleague, Mr. Ramsell, is going to be arguing as far as proof, evidence, presumption, grade, I believe, Judge.
Okay, thank you.
Judge, with regards to proof, evidence, presumption grade, that's the highest standard, it's even higher than beyond a reasonable doubt. I would submit to the court what's provided to the court today doesn't rise to that level, and ask the court not to find proof, evidence, presumption grade and to set upon in the matter.
Okay, Mr. Mace, again, you're being charged with burglary with assault or battery. I've reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great, therefore you are to be held without bond until further order of the court. This order is without prejudice for the defendant to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. Thank you, sir. Good luck.
And Your Honor, the state would ask for an additional order of no victim contact.
And sir, you're to have no contact with the victim, either direct or indirect. Do you understand, sir?
No. Can you repeat yourself?
Yes, of course. You are to have no contact with the victim, either directly or indirectly, and you must remain at least 500 feet from the victim. Do you understand?
Yes.
All right. Good luck, sir. Mr. Nathan Samuel Manas?
He's here, President Judge of Maine.
Hi. Hi, sir. You're being charged with driving while license suspended, habitual. State?
Your Honor, the state would be requesting that the $750 bond be kept in place.
Okay. Mr. Romero, what say you?
Judge, he informed me his girlfriend is going to be posting his bond. The only thing we'd be asking you to do is would you sign an order allowing a photograph of Mr. Manis's injury?
Okay, yes, we will allow that, and sir, we do find probable cause, and your bond will be set at $750. All right, good luck.
Thank you.
Yes.
Mr. Robert Derek Gunn?
Mr. Gunn, come on up, please.
Good morning, Mr. Gunn. Let's see, there's 8 charges. The first one is grand theft auto. The second is resisting officer, obstruction without violence, petty theft, grand theft auto, resisting officer, obstruction without violence, driving while license suspended, habitual, avoiding a red light, and driving wrong lane or side of the road. State?
Your Honor, first to advise the court, Mr. Gunn is out on 2 separate felony offenses, one for possession of cocaine, the other for grand theft auto. It is up to the court whether you decide to sua sponte or not, revoke his bond and release conditions on those cases. That being said, I do believe based on that and his criminal history, Mr. Gunn's criminal history includes 2011 possession of cocaine, 2.5 years state prison, 2011 DWS habitual offender, 2 separate cases, 30 months Florida State Prison, 04 battery on a law enforcement officer and fleeing and eluding, 55 months state prison as a habitual offender, 05 2 counts of battery on a law enforcement officer, escape, possession of cocaine and marijuana with intent to sell or deliver, 55 months state prison as a habitual offender, possessions of cocaine in 02, 2000. In 98, he had another escape. He was sentenced to a year and a day state prison. 98, aggravated fleeing and eluding and grand theft, a year and a day state prison. So I believe Mr. Gunn is a danger to the property of the community, and also I believe Mr. Gunn poses a flight risk considering he's had multiple escapes in his past, a prior aggravated fleeing and eluding, and the court has now found probable cause for fleeing and eluding law enforcement when trying to take him into custody in this matter.
I'm sorry to interrupt. Are some of these duplicate charges, or? 'cause I
No,
see
there's more
offense
than, there's
numbers.
multiple probable cause affidavits.
Because I only saw one. I only have one, unfortunately.
Hold on one moment. Do you want to see my packet?
Yes, please.
Okay. Just one moment, sir.
Thank you, Judge.
Good morning, Your Honor.
Hello.
Spanish interpreter.
Oh, thank you for coming. Mr. Romero, your colleague is just looking at my packet, okay?
No problem, Judge, thank you.
Just one thing I noticed, Judge, in regards to the Lowe's grand theft. I'm sorry, I didn't see. Thank you, Judge.
Your Honor, for the reasons stated previously, the state's gonna be requesting bond increases on all the grand theft autos and grand thefts. I believe there's a total of 5 counts to $5,000 each. On the count, charge 15, the fleeing and eluding at a high rate of speed, second-degree felony, a bond in the amount of $10,000. Additionally, and the state is seeking those bonds because I believe they are a necessary deterrent against Mr. Gunn committing any new law offenses and returning to court. Also, the state's gonna be requesting, should Mr. Gunn post his bond, that he be supervised by pretrial release with a GPS monitor, so that should he not return to court or committing new law offenses, law enforcement would know of his whereabouts.
Okay, sir, so if he does post bond, you're asking that he wear a GPS locator?
Yes.
Anything else?
Nothing else, Your Honor.
Anything else, Mr. Romero?
Yes, Judge, and speaking of Mr. Gunn, he's 37 years old, been residing here his whole life. Unfortunately, at this time, he's facing a very bad financial situation. He is homeless. However, he does have friends in the community, specifically a friend that he told me that he can live with if he gets released, who lives in Pompano. Judge, what I'd be asking you for is, considering he has no money in the bank, he owns no property, I do understand the state's concerns as far as his priors and the fact that I believe he's out on 2 cases from what the state did say. Judge, financially, he can't afford to post any sort of bond. What I would ask you to consider is placing Mr. Gunn on pretrial release with a level 2, no objection to the GPS monitor, so that way the court could be assured that Mr. Gunn is being supervised and be assured as far as where his location is at all times. Besides that, Judge, we'd also ask you to sign an order allowing us to photograph Mr. Gunn's injury. So those are the 2 requests the defense would be asking for, Judge.
Okay, so the court does find probable cause. The court will not touch the bond on the other cases. With regard to grand theft auto, bond's gonna be set at $5,000. Charge 2, ROR. Charge 3, bond will be set at $100. Charge 4, grand theft auto, will be $1,000. Number 6, driving while license is suspended, habitual, bond will be set at $100. And resisting officer obstruction without violence, bond will be set at $100. In addition, if he posts bond, The court's gonna order a GPS locator, and then lastly, Mr. Romero, did you want a order for photographs?
That is correct, Judge. And also with the GPS monitor, I believe there's a cost associated as far as $5 per day. He did fill out a financial affidavit. I believe he's going to be determined indigent. Judge, I'd ask you to waive that cost.
Will do, we'll waive the cost.
Thank
Your
you.
Honor,
Yes,
they advised that the defendant is homeless. Is he going, did they say he's gonna be living with a friend?
he's gonna live with a friend in Pompano, is that correct, Mr. Romero?
Yes, Judge.
Can he
Yes, do you want
advise
that
of-
address now?
Yes, please.
Could we get that address, sir?
I don't know the address right now.
Okay, great.
He doesn't have the
You know his
exact
phone
address as
number?
far as.
Do you have a phone number?
It's in my phone. I
It's
don't
in
have
his,
my phone.
his phone is, I believe, in your property? Okay, Judge, the friend that he's gonna be staying with, his contact phone number, is in his phone, which is in property, so would you sign an order allowing him access to his phone?
Yes.
Your Honor, did you set a bond on count 15?
Pardon me?
Count 15, did you set a bond? Yeah, can you, I'm sorry, can't, yeah, because it was jumping.
Okay, so you want me to go from the beginning?
Yes, please.
All right, so count one, the grand theft auto bond's gonna be set at 5,000. Number two, resisting officer obstruction without violence, ROR on that. Number three, the petty theft bond set at 100. Number four, grand theft auto bond is set as 1,000. Number five, resisting officer obstruction without violence is set at 100. Driving while license suspended habitual is set at 1,000.
There's a second, I believe there's a second
There's more
page.
pages, Your Honor.
Oh, yes, pardon me. For number nine, the grand theft auto bond will be set at 1,000. Number 10, grand theft 300 to 5,000, pardon me, will be set at 1,000. 11, grand theft auto 1,000. Number 12, driving while license suspended, third or subsequent offense, $750. Number 13, resisting officer obstruction without violence, ROR.
There's more, Your Honor.
Got it. Driving with suspended license, habitual traffic, that'll be at 100. Number 15, fleeing, eluding law enforcement officer at high speed. What was your recommendation on that, State?
10,000, Your Honor.
That'll be at 10,000. And driving on the sidewalk path, State?
Your Honor, that's a traffic infraction, it's non-criminal.
Okay, thank you. Okay, sir, good luck.
Your Honor, I apologize. What level pre-trial would that be? Level 1 or 2?
It'll be level 2. Okay, does anyone need anything else? Okay, thank you. Sean Bonita?
Yes, ma'am. Can you see our president, main judge?
Hi, good morning, sir. You're being charged with burglary of an occupied structure, unarmed, State?
Your Honor, this is actually, I'm asking that the $1,000 bond be kept in place. Judge Lynch signed a transport order, having the Department of Corrections, I believe he's in, state custody right now,
No objection.
having transferred to, court.
Okay, thank you, sir. The court's gonna find probable cause, and we'll keep that bond at 1,000, okay? Good luck.
Good luck, sir.
Derek James Smith?
Let's come on up, please. Page 18.
Good morning, Mr. Smith. You're being charged with burglary of an unoccupied structure, unarmed, petty theft, first degree, burglary of unoccupied structure, unarmed, and resisting officer obstruction without violence. State?
Yes, Your Honor. Mr. Smith's history includes 2011 burglary of a conveyance and felony theft, 26.5 months Florida State Prison. 2011 felony theft resisting a merchant, 26.5 months Florida State Prison. 2011 burglary of an occupied dwelling, 16.5 months Florida State Prison. Theft 2010, grand theft 08, theft 08, theft 09, criminal mischief 08. Based on Mr. Smith's history involving theft and burglaries, the state is going to be requesting bonds on counts 1 and 3 in the amount of $5,000 each.
What about 2 and 4?
I'm fine with no bond being attached. I'm just seeking a total bond of 10,000.
Okay. Mr. Romero, what say you?
Judge, we'd be asking for your honor to consider $2,500 on count one, $2,500 on count three. Mr. Smith is a plumber. He's been doing that for a number of years now. He's making approximately $16. However, he lives with his parents, and he helps his parents with the expenses as far as rent, utilities, and everything like that. He doesn't believe his parents, that's who's gonna try and depend on his bond, can come up with the 10, so that's why we'd be asking you to consider $2,500 on one and $2,500 on three.
Okay, the court's gonna find probable cause, sir. With regard to count one, the court's gonna set bond at 2,500. With regard to count three, the court's gonna also set bond at 2,500. Sir, you're to have no contact, what was it, a Shell station, gas station?
That was one, and the other was Boat World.
Okay, sir, you're to have no contact with the victims, with any of the employees in any of those stores, and I want you to stay at least 500 feet away from them. Do you understand, sir? Good luck.
Judge, also, I forgot to ask this request. Would you sign a photo order so we can photograph his injuries?
Absolutely, yes.
Thank you, Judge. Mr. Taylor, come on up, please.
Mr. Patrick Franz Taylor? Hello,
Good
sir.
morning. Good morning, Your Honor.
All right, so it looks like we have 4 charges. We have petty theft. Number 2, resisting officer, obstruction without violence. Number 3, probation violation or community control. And number 4, violation of community control felony. And sir, we do have a hearing scheduled in Division FF for your VOP on 10/10 at 8:30 a.m. State, what say you?
Your Honor, in light of his no bond hold, I'm just asking that the standard bond on count 2 be kept in place.
No objection, Judge.
Okay, so we'll do that with count 2 with the standard bond of 100. And sir, you have that hearing again. Let me just tell you, Division FF, October 10th at 8:30 a.m.
What room? Judge, Mr. Taylor's inquiring what room number specifically is
Okay.
going to be in?
I'm not sure, but let's see if I can find out. Does anyone know?
One moment.
Pardon me?
Judge Colra,
It's Judge Cholera?
yes.
Okay. We know it's in front of Judge Cholera, but we're still trying to find the room. If not, Mr. Romero, can you assist them?
I don't have right now any information as far as what room is assigned to which judge.
57.
Okay, sir, somebody will transport you. I don't have the room number, but you're gonna be in front of Judge Cholera.
5750.
Oh, okay, we have it. It's
5750, so you can tell your family.
Okay.
5750 on that day, October 10th at 8:30 a.m., okay? Good luck, sir. Thank you.
Okay, good luck, sir.
Thank you.
Willie Daniels?
Mr. Daniels, come on up, please.
Good morning, Mr. Daniels. Let's see, we have 4 charges. Number 1 is possession of PVP. Number 2 is probation violation or community control. Number 3 is probation violation or community control. And number 4, probation violation or community control. And sir, you do have a hearing on your violation of probation in Division FA on October 6th, 2017 at 9 a.m. State?
Your Honor, I'm just asking the $1,000 bond be kept in place.
No objection, Judge.
Okay, so the court does find probable cause, and we will keep that standard bond for charge 1 for $1,000. And don't forget, sir, again, you have a hearing in Division FA on October 6th at 9 a.m.
Good luck, sir.
And, Your Honor, just to advise the court, the Spanish interpreter is present.
Okay, thank you so much. Are you in a rush?
Habla español?
Okay, let's see what we can do here.
There's one gentleman here, I believe, ¿qué es su nombre? Mr. Alfredo Rodriguez, Judge, I'll try and locate him on my docket.
Okay, and just give me one moment, because I don't have a docket. I go through,
It's about three people down from the last gentleman we did. So it should be close to the front of your stack, I'm assuming.
Give me the last name again, Mr. Romero?
Alfredo Rodriguez.
Okay. All right, is everybody everybody ready, or do you need a moment?
I'm ready.
Okay,
This is 3 down.
okay. Please raise your right hand. Do you solemnly swear and affirm that you will be interpreting according to your standards, correct, sir?
I do, Your Honor. For the record, Igor Feliciani, F as in Frank, ELICIONI, Spanish interpreter.
Okay, thank you for coming. Okay,
Thank
Mr.
you.
Rodriguez, you're here today, you're being charged for violation of probation.
Señor Rodríguez está aquí el día de hoy acusado por violación de su probatoria.
Okay, sir, you have a hearing scheduled for your violation of probation in Division FP on October 9th, 2017 at 9 a.m.
Señor, usted tiene una audiencia agendada para su violación de probatoria en la sección FP 0019 en octubre 9 del 2017.
What say you, State?
Fiscalía, ¿qué tiene que decir?
Your Honor, his judge signed a warrant for a no bond hold.
Su juez acaba de firmar una orden para no liberarlo bajo fianza.
Okay, Mr. Romero.
Nothing to add, Judge.
Okay, just to reiterate again, your client does have a hearing on October 9th at 9 a.m.
Solo para repasarlo nuevamente, su cliente tiene una audiencia el día 9 de octubre a las 9 de la mañana.
Good luck, sir.
Thank you, Judge.
Buena suerte, señor.
¿Alguien más habla español? ¿Alguien más habla español? Nobody else here at Maine requires the service of Spanish interpreter, Judge. I don't know if any other facility needs one, though.
Okay.
Would you like to announce, Your Honor? ¿Alguien necesita intérprete español? ¿Necesita intérprete español North Broward? Have a wonderful day, Your Honor.
Thank you. All right, Denny Lamore.
Mr. Lamore, come on up, please.
Good morning, Mr. Lamore. You're here today. You're being charged with violation of community control, and you have a hearing set in Division FH on October 9th at 9 a.m. State?
Again, Your Honor, this is an order from his assigned judge.
Okay. Mr. Romero?
Nothing to add, Judge.
Okay, just to reiterate again, sir, you have a hearing on October 9th, 2017 at 9 a.m. Good luck.
Thanks a lot. Good luck, thank you.
Jimsley Colbert Dumasel?
Judge, I have a probable cause argument as to count one.
Mr. Doomsley declined the services of public defender, Judge.
Withdraw.
Okay, sir, do you have a private attorney?
I want to hire one.
Okay, so we could resit this case if you want to hire a private attorney, okay?
No, I'm trying to go home. I'm on bond.
Hold on one moment, let me see. Ladies and gentlemen, in this type of situation, would we reset it to an afternoon docket? So we can
It's his call. If he wants
Requesting
to
a
go
bond.
forward,
Yeah.
he can go forward. If he wants to have it reset for this afternoon or tomorrow, to have an opportunity to retain counsel, that's permittable under the rules of procedure.
I'm bonding out.
Sir, so in other words, we could reset it for this afternoon so you can call your
No,
attorney?
no,
Or reset it
no,
for tomorrow?
No, I was trying to get a bond out.
Okay.
I got bond.
All right. Mr. Romero's there. Would you like to have an opportunity to speak with him?
What are they doing? I'm trying to get bond if I can bond out.
Okay, sir.
I got bond.
The court's gonna find probable cause with regard to charge 1, use or display of a firearm during a felony, and number 2, possession of cannabis over 20 grams. State, what say you?
Your Honor, would just be requesting a $2,000 bond on 1 and asking that the $1,000 bond on 2 be kept in place.
Okay.
Okay, sir. So the court again finds probable cause with regard to charge number 1. We're gonna set bond at $1,000 and charge number 2, $1,000. Good luck.
All right, thank you.
Hakeem Norcius?
He's approaching, Judge. He also declined the service of public defender.
Hello, sir.
How you doing?
You have 3 charges: possession of cannabis over 20 grams, number 2, probation violation or community control, and number 3, probation violation or community control. And, sir, you do have a hearing scheduled in Division FB DP on October 9th at 8:30 a.m. State?
Your Honor, in light of the no bond holds, just asking that the $1,000 bond be kept in place on count one.
Okay, sir, again, the court will find probable cause on all three counts, and with regard to count one, the court will set bond at $1,000, and with regard to your hearing, just to remind you again, for your violation or community control, you have a hearing in Division FB-DP on October 9th at 8:30 a.m. All right, good luck, sir.
Joseph Davis?
Joseph Davis?
Your Honor, he's gonna be reset for PM.
Joseph Davis will be in the PM?
Yeah.
Thank you. Maurice Miller?
He's here, main judge?
Hello, sir. You're being charged with possession of cocaine. State?
Yeah, it's not filed. Your Honor, just asking that the standard bond of $1,000 be kept in place. Mr. Miller is out on ROR from July this year on a possession, actually he's out on bond on a possession of cocaine. Additional priors include 2016 possession of clonazepam, 2015 possession of hydrocodone, amphetamine, lorazepam, alprazolam, 2015 delivery of PVP, 2010 possession of cocaine, 2004 robbery by sudden snatching and battery. He was sentenced to just under 30-month state prison. 3 counts of dealing in stolen property. 04 he received the same prison sentence concurrently. 04 2 separate burglary of structures, and he received the same prison sentence on those cases as well.
Thank you. Mr. Romero?
Nothing to add, Judge. No objection to the $1,000 bond.
Okay, the court does find probable cause, and we will set bond at $1,000. Good luck, sir.
Thank you, Judge.
David Brian Pagura Solares?
Judge, I believe he bonded.
Okay, thank you, Mr. Romero. Good morning, Mr. Berto. How are you?
Good morning.
Okay, you're being charged with grand theft and committing theft, resisting recovery of property. State?
What did he get out of prison? Your Honor, I'm gonna ask that the $1,000 bond be kept in place on count one. To his criminal, based on his criminal history. What? June?
No objection, Judge.
He was released, okay.
I think there's no objection.
No, that's why I stopped.
Okay, all right, I just didn't want you to
Yeah,
feel
no,
like you
I-
were getting cut off.
I appreciate
Okay,
Judge.
all right, wonderful. Okay, sir, the court is gonna find probable cause with regard to count one and count two. Bond at grant for count one will be set at 1,000. And for number two, ROR.
Okay. Contact your mom, see if you can post your bond, all right?
Everton Michael Satao?
I believe he bonded, Judge.
Okay, thank you, Mr. Romero. Scott Francis Vicinata?
He's here, President.
Hello. Okay, sir, you're being charged with possession of cannabis, 20 grams or less, and probation violation or community control. State, what say you?
Your Honor, in light of his no bond hold on count two, state is just requesting the $100 bond be kept in place on count one.
Mr. Romero, what say you?
Nothing to add at this time, Judge.
Okay, sir, so, bond on count one will be 100, and with regard to your violation or community control, you have a hearing in Division FE on October 10th, 2017 at 8:45 a.m. Okay, sir?
Where did it happen?
You have a court date on October 10th at 8:45 a.m.
Oh, yes, I thought you said the 17th.
No, not December, it's October in a couple days.
I just said,
No, not in December.
It's, October 10th,
October 10th,
2017
8:45.
at
But I
8:45
do
a.m.
have a bond?
For count one, your bond will be set at 100. Shane Lewis?
Mr. Lewis, come on up, please.
Good morning, Mr. Lewis. You're here on two charges, violation of probation felony, number one, and number two, violation of probation felony. What say you, State?
Your Honor, I'm just asking that the bond set by his judge are kept in place, or no bond.
Nothing to add, Judge.
Okay, the court will adopt the state's request. Sir, you have a hearing on Division FG for your violation of probation on October 9th at 8:30 a.m. Okay? Good luck. Juan Antonio Rodriguez?
He's here, present, Judge Amain.
Hello, sir. You're being charged with aggravated assault with intent to commit a felony. State?
Your Honor, I see no criminal history. However, based on the totality of the allegations, Your Honor, and the weight of the evidence against Mr. Rodriguez, I'm going to be asked for concern for the safety of the alleged victim, as there are allegations that Mr. Rodriguez has made threats against the alleged victim upon his release. I'm going to be asking for a bond in the amount of $10,000. Should Mr. Rodriguez post this bond, that he be placed under the supervision of pretrial release with a GPS monitor. Additional release conditions, that there be no victim contact, and that Mr. Rodriguez not be in possession of any firearms or weapons during the pendency of the case.
What say you, Mr. Romero?
Judge, he was born here in Florida. Right now, he's not employed. He's looking for work. Financially, from what he tells me, he has no money in any sort of bank accounts or no sort of trust funds, no sort of ownership in any stocks or bonds. He owns no property or anything like that. He lives with his mother in North Lauderdale. Judge, financially, he's indigent, so I'd ask you to take that into account in determining a reasonable bond on Mr. Rodriguez's behalf.
Anything else, State?
Your Honor, I understand the defense argument. I just think the aggravating factors in this case outweigh the mitigating factors.
Okay, sir, the court is gonna find probable cause. We're gonna set your bond at $10,000. If you do get released on bond, you're gonna be out on pretrial release with the GPS locator. And sir, you are to have no contact with the victim. Do you understand?
Sure.
No direct contact? Mr. Romero, can you get your client back? Sir, I just want you to understand you're not to have any contact, direct or indirect. Do you understand? Do you understand, sir?
Yes. I guess so, yeah.
And I want you to stay at least 1,000 feet away from the victim at all times. Do you understand that, sir?
Yeah, I understand that.
Thank you. Good luck. Thanks, Mr. Romero.
To the court. Your Honor, and as far as the state's request regarding no weapons or firearms?
Yes, sir, you're to have no... Mr. Romero, can you get your client back? Okay, State, what in particular are you asking?
I was requesting an order, that he not be in any possession of any firearms or weapons until further order of the court.
Okay, it's granted, sir. You're not to have possession of any firearms or weapons until further order of the court. Do you understand?
I understand that.
Okay, wonderful. Thank you. Michael John Roberts?
Mr. Roberts is here, present, Judge Amain.
Hello, sir. You're being charged with unlawful possession of a personal ID of another state?
Yes, Your Honor. The state is going to be seeking a bond increase from $5,000 based on the amount of credit cards that were found in his possession, the strength of the evidence that Mr. Roberts also allegedly gave a post-mortem confession to possessing these items. Additionally, based on his criminal history, 2016, he violated a domestic violence injunction and was convicted. 2015, possession of PVP, he violated probation. 2015, possession of PVP, he violated probation. 2014, possession of PVP. End of record.
Thank you, State. Mr. Romero?
Judge, Mr. Roberts is 25 years old. He's been residing here his whole life. Unfortunately, he was working. Right now, he's currently looking for, he lost his job, he's currently looking for work. He was doing landscaping. He was getting paid approximately $80 per day. He lives in Lauderhill with his sister. That's who he's going to be counting on to hopefully help post his bond. She works for Papa John's. Judge, I understand he does have priors, but from what the state read off, it's not extensive. I believe most of them were involving drug offenses. Judge, at this point, from what he's advised me, he cannot come up with what the state is suggesting as far as $5,000 bond. It's going to be hard for him to even come up with the $1,000 standard bond, which is presently set. I'd be asking you to consider reducing it from $1,000 to $500, and maybe that's something his sister can afford.
Okay, the court is gonna find probable cause and bond will be set at 1,000. Good luck, sir.
Judge, would you sign the phone order?
Yes.
Thank you, Judge.
Antonio Mohan?
I've been advised he bonded, Judge.
Thank you. Leonard Spano?
Mr. Spanner is approaching, Judge. He declined the services of public defense.
Hello, sir. Do you have a private attorney?
I was gonna hire somebody.
Okay, do you want to try to reset this for this afternoon or for tomorrow?
No.
Okay. And you're declining the services of the public defender, correct?
For my trial, yes.
What a,
I'd like to hire a private attorney for my trial.
okay, but you want to proceed with this hearing without your attorney, or do you want us to reset this?
Sure, I'll proceed.
Okay, sir. You're being charged with possession of cannabis over 20 grams, disobeying or avoiding a red light, and driving while license suspended without knowledge. The court does find probable cause. State?
Your Honor, I'm just asking that the standard $1,000 bond be kept in place.
Sir, how long have you been living in Broward County?
I've been living in Broward County for 3 years and West Palm Beach County for 12 years.
Okay, and do you work?
I own Masterpiece Barbershop and Salon. I employ 8 people.
Okay.
So that's my ties in with the community. I was hoping you'd take that into consideration. And I haven't had any problems with the law in almost 20 years.
Okay, hold on one moment. State, can you confirm priors?
I didn't see anything, Your Honor.
Okay, sir, the court is gonna find probable cause with regard to charge 1. We're gonna set bond at $500, okay?
Thank you very much. Ma'am, will I be released today?
If you can post the bond.
Okay.
Anthony James Bibber? Good morning,
Mr.
sir.
Bibber is here present, Judge, I mean?
Hi. Sir,
Hello, Your Honor.
you're being charged with violation of probation, and you do have a hearing set for that. So, Mr. Romero, if you don't mind taking this down, you have a hearing in Division FF for your violation of probation on October 10th at 8:30 a.m. Okay?
Okay.
Good luck, sir.
Good luck.
Sherrod McFadden?
North Brown.
Reset.
Oh, it's a medical reset?
Yes, Your Honor.
Okay, thank you. Jonathan Barrett?
He's here present, Judge.
Okay, thanks, Mr. Romero. Okay, sir, there's 5 charges. Number 1 is grand theft auto. Number 2 is carrying a concealed firearm. Number 3 is possession of Xanax. Number 4 is possession of cannabis, 20 grams or less, and number 5, driving while license suspended, first offense.
And Your Honor, I have an additional report I provided to Your Honor and Defense Counsel. It's the original stolen vehicle report that's referenced in the probable cause affidavit.
Okay, I just need one moment to look at this.
Sure.
Okay, sir, anything else you wanted to add?
No. Oh, well, and not as far as probable cause, no.
Okay. All right, Mr. Romero?
Judge, I don't know what's the state's position on the bond.
Okay.
Your Honor finds probable cause?
Yep, the court does find probable cause.
Your Honor, I'm asking that the bonds be kept in place. To advise the court, it appears Mr. Barrett is out right now and are resisting without violence, leaving the scene of an accident in DWS. He also had a DWS in 2015, and in 2014, uttering a forged instrument, he violated his probation and was sentenced to 90 days in county jail.
Okay, Mr. Romero?
Judge, it's being Mr. Barrett. He's been residing here in South Florida for about 23 years, his whole life. He's working. He works for a person who does home remodeling. He's been doing that for about 5 years, making approximately $12 an hour. He lives in Coral Springs with his mother in an apartment. Judge, that's who he's going to be contacting to help post his bond. He doesn't know financially he can go ahead, or his mother or his friends are in a financial position to post right now, which is currently set at $3,200. Would Your Honor consider lowering the bond on count 3 to $100, Judge?
Okay, so the court's gonna find probable cause with regard to charge number 1, bond will be set at 1,000. Charge number 2, bond will be set at 1,000. Charge number 3, bond will be set at 100. And charges 4 and 5, ROR. Anything else, Mr. Romero?
Judge, I believe the last gentleman here we have is Mr. Andre Smith McCain.
Your Honor, this is perfection. I have nothing additional to provide the court, so he should be ROR'd on all the counts except for the last one.
Okay, did you hear that, Mr. Romero?
Yes. Yes, Judge.
What?
Okay, so just to state, just to make sure we're right on the same page, so 1 through 10 is gonna be ROR?
Yes.
Okay,
The possession of cannabis with intent. Judge Davis found probable cause for that yesterday and kept the bond in place.
okay. All right, Mr. Romero, anything? You heard the state.
Nothing to add, Judge.
Okay, thank you. We'll adopt your recommendations, state. Thank you. Yes,
Well, no, is that the last charge?
yeah.
Yes, it's still 5,000.
Okay, do I have anything else to do?
I don't believe so.
Okay. Hi, I know that you came in early. Did you have anything that you wanted to bring to the court's attention? Yes.
We're just here for an assignment from Judge Schiff.
Oh, yeah, yes, excellent. Okay, welcome. I wasn't sure if you wanted to, if you had a case or, okay? Bye, Mr. Romero.
Thank you, Judge. I'll see you this afternoon.
Yes.
Awesome. Take care.
Okay, Madam Clerk.
Did you have a question?
You're still on. Yeah. Oh, yes, sorry, I'll be right with you, gentlemen. Let me just